Hi and welcome to part 2 of our video talks with Suzanne Rabb and me, Stephanie Wickenden, discussing the interfaces of IP and competition law. If you missed part 1, it's still available on our website and LinkedIn. We discussed the SkyKit case and the recent ruling from the CJU and whether trademark cluttering could be contrary to competition law. In this part, we will be exploring further interfaces between IP and competition, in particular shifting the focus to infringement rather than registration. We also compare the variations in the relationship between competition law and different IP rights. For example, there is a better developed set of case law in relation to patents and competition law. Can this be applied equally to trademark law? I'll also be asking Suzanne what her views are on the competition and IP hot topics, and in particular, what will happen after Brexit. And one thing I want to ask her myself is, could this be a time to reassess the competition and IP relationship in this country and maybe even bring in a general tort of unfair competition? So my first question for you, Suzanne, as I said, we've so far discussed competition law and registration, particularly overly wide trademark registrations. But what about the infringement side of things? Could overzealous trademark litigation, which is perhaps aimed at excluding competition rather than legitimately enforcing rights, could that be a breach of competition law?
Well, this is an example of unilateral conduct, a party taking action on its own. So picking up the points already discussed in part 1, if this is to be sanctioned at all under EU competition law and national equivalents, it would be under the prohibition on abuse of dominance under Article 102 of the TFEU. So, assuming the litigant is a party in a dominant position, do we have any examples in the case law, by analogy, where similar practices have been sanctioned? Well, it's fair to say that the categories of abuse under Article 102 are not closed. And in the past, the use of sham or bogus litigation, which is manifestly unfounded in the sense that it has no other purpose but exerting pressure on the other party out of business, that has been identified as an abuse of dominance in a seminal case, ITT Promedia and the Commission. Now, that case came into prominence in the course of the European Commission's pharmaceutical sector inquiry, where the spectre was raised as to whether the actions by large pharma companies in taking almost defensive litigation in going after generic manufacturers or other innovators, whether that could be sanctioned as having this purpose. And it's another example of those instances where the allegedly dominant party is taking action which, on one view, could be regarded as a legitimate exercise of rights that they have under other bodies of law. Because let's face it, litigation is never a slam dunk. So the question really is there a role for competition law based on the strength of the IP case? So the case law, the test, establishes quite a stringent threshold there. Litigation has to be manifestly unfounded. And in the course of that inquiry, there was some suggestion that maybe that test had been diluted. I think it is fair to say that now the case law appears to have reverted to a much more even keel, and the test remains a stringent one. But yes, it cannot be ruled out that the pursuit of litigation where it is not bona fide, it is not pursued with an intention of asserting rights which the party believes are legitimate, then that could, in appropriate circumstances, form the basis of a case under Article 102?
Yeah, one thing that I know we've discussed before is that, particularly in trademark cases, when there is genuine litigation, what is really wanted is an injunction. That is the remedy that they care about most. And obviously, an injunction in itself, keeping another party out of the market, is inherently anti-competitive in a way. So, what is your view, and do you have any case law that could assist on whether actually enforcing a trademark by getting an injunction could be problematic for competition law?
So the question of taking out an injunction to protect an IP right, in this instance, a trademark, the question of injunctions and defence of IP rights protection is very much a hot topic now, and the European Commission has developed quite an interesting body of case law, which is right at the intersection between IP and competition law. And it raises the question of Article 102 liability, where a dominant IP owner is seeking an injunction in purported exercise of IP rights. This has been raised in the context of patent rights in the so-called mobile phone wars, where an owner of a standard essential patent has sought an injunction in these circumstances, and cases involving Samsung and Motorola were early examples of this. And now there are copycat cases through national litigation there. It might be said that there are some analogies here with the themes that have been discussed in the vexatious litigation line of cases, in the sense that a question mark is raised over the legitimacy of pursuing court action in defence of IP rights, where the underlying case may not be strong. But these cases on injunctions are perhaps more readily reconcilable within a more traditional theme of compulsory licensing of IP rights, where there is much more detail in terms of the case law, where broadly the proposition is that a dominant owner of IP can be forced under competition law to license their IP rights, but it will be in exceptional circumstances. And in the course of these standard essential patent cases, the principles that have emerged and which are evolving have established that in circumstances where the dominant owner is seeking injunctive relief in the face of an alleged infringement of its standard essential patents, and the other party is willing to enter into negotiations for licensing on fair, reasonable and non-discriminatory so-called FRAND terms. And the FRAND licensing is something that standard essential patent owner has committed to respect as part of that standard setting process. Then in those instances, the seeking of that injunction can be abusive. So there are certainly the seeds of similar line of reasoning, albeit not directly in relation to trademarks as such.
So yes, I think it's fair to say that FRAND and patent thickets, alongside trademark cluttering, are two of the hottest topics in IP at the moment. Both practices are, of course, designed to make it harder for other parties to enter the market. In patents, there's the ability to take a FRAND license of a standard essential patent, as you say. However, with trademarks, the position is slightly less clear. Obviously, if a trademark is essential or creates a monopoly of something that would be essential, it would then be invalid. But could competition law and FRAND-type principles from the patent arena be applicable to trademark situations?
Well, before I answer that question, I just want to take a step back about the analogy between so-called trademark pottering and patent thickets, both of which concepts may be seen to be somewhat derogatory depending on your perspective. And just to say that these practices are aimed at making life difficult for an innovator or a new entrant or a competitor, I think we do have to question that as a first assumption. It might have that effect because the other party needs to invent around those rights or find other ways of protecting their innovation. But I think that we cannot necessarily take it as given that that is the aim of those practices. So that will always be a question when any of these cases come up in front of a competition authority, and evidence on those points obviously will be very, very important. So turning to the question of the relevance of FRAND principles, and this is common nomenclature in many different contexts. And I think it's helpful to set out different meanings of FRAND depending on the context. So IP lawyers and parties familiar with IP licensing will be familiar with FRAND commitments as an ex-ante obligation in the context of licensing and standard setting, and in patent pools, for example, where as part of collaboration, pooling together IP rights, parties will then agree that if there is any resulting innovation, that the patents, IP rights, whatever they are brought to the table, those will not later be asserted other than on FRAND terms, and the fair commitment about how those will be licensed to others. Or put it another way, allow those parties to operate in a market without being sued. We also see FRAND used in the competition arena, also ex ante, as a tool or expression of principle around the circumstances in which licensing practices will be compatible with competition law. And that's not just in the area of Article 102. We also see it in Article 101, which concerns restrictive agreements. And in the European Commission's horizontal cooperation guidelines, there is voice given to the fact that FRAND commitments can prevent IP owners from making implementation of standards difficult, and that gives rise to potential foreclosure concerns if in fact the market has been locked in to a abusive or discriminatory charging structure. So the idea here is that if FRAND commitments are part of that commercial framework, that should obviate any concerns around cooperation and other competition issues. But we also see FRAND used as an ex-post competition remedy, and that has been in situations where a problem has been identified, an abuse of dominance. So how do we correct this? What is the appropriate remedy? And an early case of the European Commission involved a situation with Rambus and its DRAM technology, where that party was accused of a so-called patent ambush, which is where it later asserts its IP rights once the technology has been accepted. And at this point, can that party charge a particular level of royalty, or should that be a zero royalty? And in that instance, effectively, that party is being required to license on FRAND terms and maybe at a zero royalty. That was a situation that was resolved through commitments, so not a final infringement decision by the European Commission, but a basis on which the case would be closed as disclosing no grounds for further action. But what it does is gives us an insight into the use of FRAND as part of competition policy. FRAND and similar concepts are also used in the regulated sphere, and whether that's part of financial services or telecoms, and certainly the UK Payment Systems Regulator has a similar presumption or principle in its ex ante regulation of the payment sector, where it's concerned with access to payment systems. So that might seem quite far removed from the current context and IP rights, but fundamentally, where one party has access to a resource or IP right or infrastructure that is essential to compete in a downstream market, there can be circumstances in which it is required to make that available to its competitors in other markets. So certainly some analogies could be drawn there from similar contexts.
Yeah, it certainly seems to me that to consider FRAND as something other than a creature of patent law principle was quite new. And I think this raises broader questions of how competition principles can be applied to different intellectual property rights. How transferable are the rules and principles governing different forms of competition and IP interfaces? And in particular, are some rights more deserving of protection than others from a competition perspective?
Well, I think it's fair to say that reflecting on the case law for many decades, a lot of the really seminal cases have been developed in the patent arena. So we certainly have a larger body of case law there. And I would like to say that perhaps all IP rights are equal, but one can certainly detect an element of recognition that some may perhaps be more equal than others, and maybe for trademarks seen as more the Cinderella of the IP world, which haven't yet had their day. But at the same time, we do see a lot of read across and a lot of evolution in how principles evolving in one area of law have been deployed in other contexts. So the technology transfer block exemption provides a framework by which licensing practices can be compatible with EU competition law provision under Article 101. And that provides a standard framework for IP rights. Now, originally, that was quite narrow, but over the years, it has developed and now embraces purchasing, licensing, or assignment of rights beyond patent rights, such as a trademark, where those are directly related to the production or sale of the contract products using the licensed technology. So there is certainly a lot of evolution there, from patent rights to software copyright, even to plant breeders' rights. Let us remember that important cases on licensing, and particularly compulsory licensing, have been developed in the area of copyright, which is probably another topic which would be worthy of a similar discussion. And the important case of McGill on compulsory licensing of IP rights involved TV listings and directory. So it might be said that the amount of investment and innovation in that form of IP rights is quite different from the financial investment or long lead time or risk inherent in patents, where very few blockbuster drugs will come onto market, and it could be argued that there is a need for greater protection there. But again, these are evolving principles, which does bring us back to some of the themes that were discussed in part one about this question of competition law and IP. Are these diametrically opposed legal systems, or are they all chasing after the same goal? So we see IP rights as providing an incentive, a reward for innovation. So the idea fundamentally being that parties will only invest in innovation if the expected payback over the recoupment period, when they have got a successful brand, a successful product protected by IP rights, is given some form of exclusivity and protection from competitors. So again, we face this constant dilemma of, for that innovation to occur, how much protection needs to be given. And it is very much a fine balance there, because let's remember that it's the prospect of high profits in later years which will keep markets competitive over the long term. But the more that later market is foreclosed to new entry, then we have concerns over market power. Market power of itself is not the target of competition law, but what is the target is the abuse. And that is one of the most controversial questions, in which many of these cases which explore more novel forms of abuse, which have been the subject of our talk today, are very, very controversial and will continue to grow.
This takes me to our final question, which is what you think the future hot topic areas of IP and competition interface are. Now, I'd like to start with one question in particular, which has been the subject of a lot of debate for well over a decade now in IP. I mean, obviously, as we've been discussing, there are competition laws in the UK, but it is well known that there is no general tort of unfair competition over here, as opposed to in the rest of Europe. UK lawyers have tried to push the boundaries and in particular extend the law of passing off into a more general law of unfair competition. This was tried in the L'Oreal and then the Diageo case, but to no avail. What will happen to competition law and unfair competition in the UK after Brexit? Do you think that will have any effect? Is it time for us to have another attempt at persuading the UK to push the boundaries of unfair competition law?
So to clarify a few principles there, so by competition law we mean the rules under Article 101 and 102 of the Treaty on Restrictive Agreements and Abuse of Dominance, and their national law counterparts such as Chapter 1 and Chapter 2 of the UK Competition Act. And those are common across Europe and are part of the EU system. When we're looking at unilateral practices, which have been the most focus of this debate, we're concerned with practices by a dominant company, which presumes a dominant market position. When we are looking at unfair competition, that is not a product of EU law as such, but is an element or action or ground that we find in overwhelmingly the civil law jurisdictions of Europe. They may be enshrined in commercial or civil codes in those jurisdictions. They do concern unilateral practices overwhelmingly, but they are not necessarily dependent on there existing some degree of market power on the part of the party that is allegedly behaving in a way that is unfair. Now, will Brexit change any of that? Could that prompt the UK to revisit its hitherto principle that we do not acknowledge this as part of our common law? Well, of itself, I would like to say that leaving the European Union does not somehow free us up to revisit this area in a way that previously we were constrained by, because it's not an indicia of EU law as such. And what is perhaps more interesting is the procedural framework under EU law, which basically says that if you have an agreement which is compatible with EU law under Article 101, then national law, where the practices affect member states, can't make that void through other legal routes. So far, so good on agreements, but it doesn't stop member states having their own rules on unilateral conduct or rules which pursue what is a predominantly different purpose. So that is the route by which these other countries are able to have these other rules which sit side by side. But at the same time, that's the similar position for the United Kingdom. So there was nothing about us being part of the EU that stopped us doing that already. So an interesting question is whether just a rethink of our whole domestic situation could prompt a more developmental approach, and maybe it will, but it's not necessarily cause and effect point as a result of leaving the EU, because we could have done this from the beginning of our membership. But an interesting point I would like to just leave you with is whether there is scope for reinvigoration of the common law restraint of trade doctrine, which can sit alongside other rules where there is a contractual arrangement, but also unilateral practices. Usually it may be a decision of a regulatory body or similar. Now, up to now, there has been a school of thought which says, well, does restraint of trade, does it do anything more than Article 101 in terms of agreements? And up to the High Court, at least, the view has been taken that the modernisation regulation and framework that I've just discussed really leaves a role for restraint of trade, which is virtually non-existent. But even before Brexit, it's perhaps disappointing that that proposition wasn't properly tested, because there is an interesting question as to whether the restraint of trade doctrine actually does pursue a predominantly different purpose to Article 101. So that route might still be open right now, given that restraint of trade has this overall public interest angle to it, whether we're looking at is it reasonable as between the parties or overall in the public interest where there isn't a contractual arrangement. So I'm just wondering whether some more agile thinking or creative litigant might put back on the table a role for restraint of trade in the future because of that overwhelming background of public interest, which we discussed at length in part one. So that brings us to consider in the coming months or years what might be some of the interesting interface areas. So I do expect that litigation, settlement, injunctions, that will continue to be an interesting area which we've seen in the patent space, and it may well have its manifestation in relation to other IP rights. Abuse of regulatory procedures, whether that's seeking protection, extending protection, withdrawing products from the market, etc., will continue to provide a fertile source of litigation for opportunistic claimants. Another interesting area is around selective licensing, and perhaps this also has a manifestation in those areas of, well, who are we going to oppose? Whose trademark registration will we resist? Might we call a truce on this in relation to competitor A because they don't typically object to our opposition, our rights being pursued through that route. So there may be an interesting question there as to whether that decision, by analogy with the selective licensing cases, could take the form of an abuse of dominance allegation. Are you treating all competitors like for like? Why are you opposing this trademark registration and not another in circumstances which on the merits look very similar? Another area is around abuse of technology, the question of whether the practice of innovation itself, producing next generation products, could that ever be an abuse? Isn't innovation a good thing? But the concern has been raised where these next generation products, which might not necessarily be bringing value on one party's view of the world to the customer, is the aim of this simply to make life difficult for competitors who may have formulated their options based on a legacy product? But I wonder here if the real target for complaint there is not so much a competition issue, but is more one around consumer protection. Should we be paying more for next generation products because now version 10.0 has now been taken away by version 14.0. Oh, and I can't get my compatible consumables, so I've got to pay for these more expensive ones. Is this an abuse of dominance, or is this a consumer protection issue? And then finally, perhaps more of the business as usual, day-to-day IP licensing arrangements, where scrutinising those for potential competition issues will continue to be very important. And I think that's where those familiar with an IP licensing context may find it surprising that terms such as field of use agreements, non-assert provisions, all of those things which are business as usual in IP rights can actually create competition questions, and perhaps looking more closely at the technology transfer block exemption and its multiple 200 plus guidelines can actually provide you with a default position which gives a high level of certainty that those licensing firms are compatible example, with competition law. Should you wish to do something, though, that is not within that framework, then you are looking at a self-assessment of those licensing terms based on a full assessment under Article 101 or national law equivalent, and that will remain the case regardless of any future trading arrangement that we may conclude with the EU and how much we need to sign up to the EU framework as the level playing field, because those principles are very much part of the United Kingdom's competition law, and there is no obvious sign at the moment, at least, that the Competition and Markets Authority wants to move very far away from that for the foreseeable future. So that will continue to be a standard area for examination as we move forward. So very much some familiar issues, but some very novel ones, ranging from the weird and the wonderful to, from some viewpoints, quite wacky. And I think the next few years will define some important principles, but most importantly, how transferable are they to different contexts? Claimants might well be emboldened by the latest line of patent wars cases. Potential defendants, again, will be seeking to make their best case on, are they dominant in the first place? What's the relevant market at all? The mere fact that I have an IP right does not make me dominant. And unless you establish that with a high degree of certainty, we're not even talking about abuse. So I will leave it there. Those are my thoughts on interesting developments going forward. I will hand back to Stephanie to have the last word.
Thanks so much, Suzanne. It sounds like we're certainly not going to struggle for new material for further talks. Hopefully at some point we will be able to break out of our video talks into the real world. But until then, thanks very much for watching, and we hope you found it interesting, and perhaps even we might have given you some ideas for creative litigation at the IP and competition law frontier. If you'd like to get in touch, please do. Our contact details are on the slides now. We'd particularly love to hear if you've got any suggestions for future topics for us to discuss. Please do get in touch, and we look forward to seeing you in our next part. Thank you.